So today's arraignment, you have this is where we're going to take your plea, guilty or not guilty. If you want to plead not guilty, would you like to proceed pro se without an attorney, hire a public defender, or private counsel? Did you know?
I'm here in my proper person.
Right. So do you want to proceed without any attorney?
Yeah, I don't need a bar association.
Okay, great. So I'm just going to write on here that you plead not guilty, and we're going to set it for a pretrial.
No, I do not.
Pleading not guilty,
No.
correct?
No.
So I can.
I'm here for a hearing.
Right, and this is your arraignment. So I'm giving you your hearing, and we're going to set it for a pretrial.
No.
What do you want then, sir?
I need to talk to the judge because I have a motion to dismiss this charge.
Well, we don't have the motion.
Okay, that's okay. I can enter it into the court. This is the court of record.
I can ask the judge if you want to do that orally,
Okay.
but I'm not sure that he's going to come out on the bench when we don't have a motion. So.
Okay, but this is a court hearing, right? Where I'm supposed to come see the judge, correct?
It's an arraignment where you enter a plea.
So that you do that with a judge, correct?
Or you can do it with me, the prosecutor.
So are you representing me then?
I don't represent you, no.
Oh, okay. Then we need to see the judge, I believe.
Okay.
It's my right to see the judge. Due process of law. No, Your Honor. I motion for dismissal with prejudice based on lack of jurisdiction for failure to state a case of action for which relief can be granted.
Okay. You are certainly entitled to have the motion heard, but today is not the day for that motion. You'll have to file that motion. It hasn't been filed.
I just filed it, Your Honor. This is a court of record, correct?
Yeah, was it done downstairs? Did you file it downstairs?
No, but per 5 U.S.C. 556, I believe it is, it says, here, where's it at in there? That it can be done verbally within the court, that actually you can't stop me claims for money or benefits applications for initial license to agency. Oh, wait, no, that's not, where's it at? Consent of the interest of justice. The policy of the underlying statute administered by the agency consider a violation of section 554D of the title of sufficient grounds for decision adverse to the party who has knowingly caused such violator or knowingly caused such violation to occur. The party is entitled to present his case or defense by oral or documentary evidence submit rebuttal evidence and to conduct such cross-examinations. So this is a court of records, so by me stating it in open court, that is filing the motion orally.
Our local rules won't allow for that. We have to come up with some type of a written notice of the state to be on notice that they can answer that.
Okay, well, for Idaho Code, Title 19, Section 615, procedure upon arrest without a warrant, when an arrest is made without a warrant by a peace officer or private person, the person arrested must, without unnecessary delay, be taken before the nearest or most accessible magistrate in the county in which the arrest is made, and information stating the charge against the person must be laid before such magistrate. That's part of due process of law, Your Honor. So I was actually deprived of my right to liberty before due process of law, and the instrument that did deprive me of my liberty is falsified. Per which the ticket states there's several inaccuracies. One, we'll just start at the top. This was done by the officer under the penalty of perjury. he did say that that I identified myself verbally, yet he goes on to give my driver's license number, that my height and eye color from my driver's license, not verbally. Then he also said the location of the infraction was West Gate in Nampa, Idaho, which is not within Boise County or Boise City jurisdiction. And then he also said that he did certify personally upon me, which that's not true either. This ticket was not given to me. The cop would not give me the charge up to the point where I had to get the charges from the jail so that I could bond out. I believe it's under section USC Title 18, 241 and 242. It's a conspiracy to deprive me of my rights. I was arrested for protesting, which is a protected right by the Constitution, which the cop clearly stated he understood I was protesting when he approached me, but decided to try to ask me for my ID anyways. And then did put hands on me, did assault me, and took me into custody and deprived me of my liberty without due justice of law. So by the origination of the case, it is done through fraud and perjury. So I move for it to be dismissed based on that there is no evidence against me to move forward with this case. The evidence was never brought before a judge. I was incarcerated against my will without due process of law. So by Idaho statute, by the Idaho State Constitution, by the National Constitution, the cop and anybody who after knowing the situation and the facts that are entered into the case does continue to deprive me of my rights is subject to Title 18, 241 and 242, conspiracy against rights, deprivation of rights under color of law.
And again, Mr. Jones, I just want to make sure that you understand this. You are absolutely entitled to make these arguments and to have a judge do them. And I am more than happy to do that. But today is not the day that we do that. I have to set this for a hearing to be heard on the merits. And so you can absolutely bring each and every one of these claims to a judge. I just need to set that for a different day for that to take place.
But see, before the pleading or any other process can go on, you need to show that there was probable cause for me to be.
You are in error. Your understanding of the law is not accurate.
Okay, it's pretty clear, Your Honor.
It is very clear. I've been doing this for only about 19 years, so I'm pretty sure I'm aware of proper procedures. I want to give you an opportunity to be heard. I absolutely want you to have that chance. It just cannot be today. You have to file these motions to be heard, and then each and every one of these can be addressed. As long as that procedure is followed, all of these claims can be heard.
But see, Your Honor, by the letter of the law, the case can't even originate because it originated from a place of perjury, of falsity. And
why is it perjury? Because you say so.
It's not because I say so, Your Honor. There's documentation. I believe the court has a copy of this ticket where the officer lies not once, not twice, but 3 times on this is the instrument which put me in incarceration without seeing a judge, without my due process of law.
A judge did review that citation.
Before I was incarcerated.
After you were arrested, a judge has to review the probable cause for the arrest within a 48-hour period. Idaho law requires that. That was done in your case. It was not a hearing at which you were present. The magistrate did review that citation.
So they held a secret court outside of my knowledge?
No, it's not secret.
But I was detained and incarcerated, deprived of my right to liberty without due process of law, correct?
No.
Okay, so you can just arrest anybody and incarcerate them without seeing a judge, contrary to Idaho Code 19615?
Mr. Jones, I can tell that we're not going to have a meeting of the minds in terms of what the law requires here today. As I said, if you'd like to have these motions heard, I'm more than happy to do this. I just have to do it in a manner that is prescribed prescribed by statute and by local rules.
Yeah, such as 19615, correct? That's Idaho code. That's not a national code. That's an Idaho code.
I'm familiar with that, and
Okay.
I'm familiar that there was compliance with 19615 in this case. You and I will disagree about how that took place, but it absolutely did take place.
So I wasn't allowed to defend myself in this secret hearing, though.
The point of the secret hearing, as you call it, is simply what is required by law, that a independent magistrate review the probable cause affidavit and determine whether there was probable cause to support the arrest. That's not a secret hearing, it's not a private hearing, it's not some.
But I wasn't allowed to confront my accusers at that hearing, correct?
That's not a trial. You are allowed
Doesn't-
to confront your accuser at a trial. That was not a trial. You are entitled to have a trial in this case. I want you to be able to bring out all of these motions. I just want you to do it in the manner that is prescribed. If you want, I can set these hearings today.
But see, the problem here, Your Honor, is that this case should have never happened. And as soon as the court is aware that this case is fraudulent, I believe that in the interest of justice, the courts have an obligation to protect my rights as a private citizen. And from your oath of office, you have the obligation to protect my rights as a private citizen, which that gives me the right to due process of law, which.
I'm trying to do that. I want to give you your hearings so that.
But it's already been denied to me.
No, nothing's been denied.
My due process of law wasn't denied to me.
It's entirely possible that your case is going to be dismissed. It is entirely possible that the judge is going to say this is a miscarriage of justice. This should never have happened. All of that is possible. But we have to have a hearing with evidence, with witnesses, so that that determination can be made.
But
I can't just do it willy-nilly out of thin air because you say it is so. What if the prosecutor says, no, this isn't the way it happened? I need witnesses, I need evidence, I need testimony. I need these people in the courtroom under oath telling me what did and did not happen. Without that, I can't make a decision.
But you brought a case against me without hearing
I
that.
did not bring anything.
Okay, the courts did, I'm sorry. The courts brought a case against me.
The prosecuting agency filed a citation. The prosecutor's office is a separate entity from the courts. They're under the executive branch, not the judicial branch. We are not one and the same. I don't work, she does not work for me, I don't work for her. They are separate entities.
Okay, but they're both government agencies, correct?
Pardon me?
They're both government agencies, correct?
Absolutely.
Okay, and on the actual ticket right here, it says in the district court of 4th Judicial District of the state of Idaho comma, in and of the county of Ada, state of Idaho. So that would be a citation by the Judicial District of the state of Idaho.
No,
So it's not,
courts do not issue citations.
it states right here, Your Honor, Idaho Uniform Citation in the District Court of the 4th Judicial District of the state of Idaho in the county of Ada, state of Idaho. That's what
Which
proceeds.
judicial officer, which judge signed that ticket?
None. That's my point, Your Honor.
So the judge didn't bring it.
That's where I'm claiming that my due process of law was circumvented.
Claim only one. Here's what we're going to do. These are your options. You can either enter a plea of guilty or not guilty. If you choose not to enter a plea, then I will enter a plea on your behalf of not guilty. I will then set this for a court date.
But
At that court date, you can file whatever motions you want. Are you going to enter a plea here today?
But then if you enter a plea on my behalf, would that not be working in my behalf, which a judge is not supposed to do?
Do you wish to enter a plea of guilty or not guilty, or issue no plea today?
I wish to question the validity of the case being brought initially, even before a plea.
Based on Idaho Rule 11, I'm going to enter a plea of not guilty on your behalf, which I am required to do by Idaho law. This matter is going to be set for a pretrial conference. We'll give you a piece of paper that has that date on it. If you choose to file motions, you may do so. If you don't file motions in the appropriate way, they will not be heard.
Okay, like I stated, I did file the motion verbally with the courts just now.
It's not an acceptable method of bringing a motion before this court.
By the letter of the law, it is, Your Honor. Like I stated, please look up 5 USC 556D and what was the other one? It was 557. Both of these state that I can do it orally. This is a court of record, so I have entered it into the record.
If you wish to have your motion heard, you'll have to file an appropriate manner. That's all I can say. Mr. Jones, again, I want you to have the opportunity to bring these motions forward. I can't hear them today. That's just not the way it's done. Got a piece of paper for you here that has your next court date on it. If you wish to file motions, you can do so, and I'll be happy to hear them if I'm the judge that gets assigned to them, whatever it is. But if they're not filed in that manner, and the motions aren't being heard, you have an opportunity to be heard, to bring forth your evidence, make all of your legal arguments. You will absolutely have that right. It's just not going to be today.
So just so I'm clear on this is not a court of record?
What do you mean by court of record?
That this is the state record, the county record, a court of record. That's what the courts are supposed to be.
All of these proceedings have been recorded. There is a record of them.
Okay, so it is a court of record. Okay, thank you.
Okay, and here, sir, looking forward. Oh, I'm way up for you, Judge. Looks like December 27 at 3:50.
Am I free to go?
Yes, thanks, sir. Appreciate it.
Let's go. They brought in 2 of those.